as well as Dr. Borzu Sabahi, Professor of International Investment Law, Georgetown University in the USA, partner at Curtis Mallet Prevost, Colt and Mosley, LLP, approved according to the order of Provost, Rector of the Narikbaev Kazgiu University, number 12-02/128 of the 29th of October 2021. The Dissertation Council appointed the following official reviewers of the thesis: Kasim Sirbayevich Maulenov, Doctor of Law, Professor at the Department of Economics and Business at the International University of Information Technologies, as well as Nazgul Sabirovna Tuyakbayeva, PhD, Associate Professor at the Faculty of Law at the Kazakh National University, named after Al-Farabi. Baghdad Kuzhatov submitted all documents according to the order of the Ministry of Education and Science, number 126, dated the 31st of March 2011. All publications required by the regulations according to the dissertation topic, including publications in Scopus-ranked journals, are present. We also have a protocol of the research committee under the Narikbaev Kazgiu University, signed by the chair, Indira Uralovna Aubakirova, dated the 23rd of September 2022. The dissertation was checked with anti-plagiarism software, and we have a letter number 0240/16-01-08 of the 19th of January 2023 from the National Center of Science and Technology Evaluation, to the effect that no plagiarism was found in the dissertation. Also, we have obtained the conclusion of the Ethical Commission that all ethical research requirements were observed and complied. Therefore, we can conclude that all submitted documents are in compliance with the requirements of the Ministry of Science and Higher Education of the Republic of Kazakhstan. Thank you very much.
Thank you, Sergey Vячеslavic. If you have any questions, you can ask. Also, I wrote, please let me convey videos to Baghdad Kuzhatov for his presentation and public defense. Please, Mr. Kuzhatov.
Do you hear me?
Yes, we can hear you well.
Құрметті диссертациялық кеңес төрайымы, құрметті мүшелер, құрметті ұстаздар, қатысушылар, кеш жарық. Good evening, the chair of the Dissertation Council, the members, the reviewers, the participants. Ladies and gentlemen, good evening to all of you. Today, I'm very pleased and a great honor for me to defend my 4 years PhD dissertation. If you don't mind, Dissertation Council members, please, if I take 25 minutes for my presentation, is it okay for you? Thank you very much. My dissertation topic is revision of balance between regulatory rights and investment protection and the fair treatment, the Energy Charter Treaty framework. Please let me shortly introduce the research problem, objectives, and the significance. I have analyzed the doctrinal and the practical issues of fair and equal treatment obligation under Article 10 of Energy Charter Treaty. Generally, briefly introducing that the Energy Charter Treaty was signed in 1994 between mostly European Union countries and the former Soviet Union states. ECT supplemented the European Energy Charter of 1991. ECT is a multilateral and energy-specific sector treaty. The relevance of this dissertation derives from three interrelated matters. First, the lack of consensus on the normative content of the treaty obligation issues arising from the FET's theoretical origin and the doctrinal concept. Second, this issue has led to differing interpretations and the inconsistent application of FET obligation under the ECT that challenges the public policy objectives of the ECT contracting parties aimed at public interests, including energy security, sustainable development, promotion of clean energy, and the protection of environment. These factors breach the balance between regulatory rights and investment protection. With respect to this balance issue, you can see in the slide that from 2013, the number of investment claims is steadily increasing, with some slight drops only in 2019 and 2020. Over the last 7 years, at least 91 investor claims have been submitted to international arbitration under the ECT, inter alia FET obligation. Currently, the pleading of breach of FET appeared as an attractive alternative to expropriation disputes, especially the restricting the findings of the expropriation by tribunals instead led to finding liability based on FET. FET now, with most breaches alleged obligation, every submitted claim under FET includes FET, and the most breaches found obligation. You can see in the slide the statistics. The third reason is the ongoing modernization of the current ECT due to the several accumulated problems and the factors such as the transition from fossil fuels to cleaner renewable energy sources, political and economic changes in the energy sector. Therefore, the main aim of this dissertation is to propose scientifically sound ways in which the FET obligation under ECT needs to be crafted to ensure the protection of both state and the investor interests. Accordingly, the dissertation addresses the following research question. How does the new FET under the ECT need to be crafted to ensure ECT contracting parties and the investor interests are protected? The dissertation undertakes the following objectives: to identify reasons for the balance issue in light of specifics of the energy sector, development of various investor-state development, dispute settlement doctrinal concepts, and the new regulatory measures; to identify the theoretical basis of the FET; to propose a new construction of FET and codify delicts of FET; to propose new approaches to doctrinal concepts of the right to regulate provisions, which will ensure the protection of both ECT contracting parties and investor interests; to test the proposed new approaches and the FET wording in light of the emerging regulatory rights of the ECT contracting parties. As a result of my dissertation, I put forward 5 provisions for defense. Provision 1. The absence of doctrinal concept, ordinary meaning, normative content of FET, expansive application of the vague FET norms under Article 10.1 of the ECT by tribunals in light of arbitration practice, precedents, interpretation and recognition of declaratory sentence of Article 10.1 of the ECT as a FET delict created a strict obligation for ECT contracting parties to provide a stable regulatory framework and protect the legitimate expectations of investors in the stability of the national legislation. Such application of FET led to multi-million arbitral awards under ECT, which raised a fundamental doctrinal issue in international investment law regarding the liability of states for bona fide public purpose measures. These factors are the reasons for the balance issue. Therefore, there is a need for specific measures, such as the identification of the doctrinal concept of FET, codification, revision of treaty text, revision of approaches to the right to regulate and the FET concepts in order to ensure a balance between the regulatory rights and investment protection. I substantiate this statement based on the following. Firstly, the analysis of over 35 publicly available ACT cases in which FET alleged demonstrated that tribunals have rarely engaged in the analysis of the normative content or doctrinal concept, or instead simply referred how this obligation has been generally understood under arbitral practice, even though the previous cases are not a binding source in international law. Secondly, the interpretation of FET was in accordance with Article 31 of the VCLT, Vienna Conventional Law of Treaty, which did not fully provide the essence of FET obligation. Therefore, the scope of FET obligation was expanded unreasonably. Tribunals have recognized that the flexible nature of FET, its adaptation to the circumstance of any case. As examples, two delicts of FET are distinguished in this line. First, the provision of stable and predictable framework. The second, the protection of legitimate expectations, which evidently led to the breach of balance. Among the analyzed tens of cases, I sorted out as an example 2 awards for substantiation of my position. First is the Antin against Spain, second, Nextera against Spain. That well illustrated the balance issue. In both of them, tribunals relied on the previous ECT awards, such as Plama against Bulgaria, Electrabil against Hungary, where the first sentence, in particular the wording, stable conditions, was interpreted as a part or related to FET obligation. Two tribunals referred to the European Energy Charter objectives and the first sentence of the Article 10.1 and the arbitral practice. More importantly, stability obligation was linked to legitimate expectations of the investor based on the arbitral practice established based on the Tecmet against Spain, Occidental against Ecuador, and the Argentina cases. In both of these awards, preference was given to breach of FET obligation. Therefore, it led to the liability of the ECT contracting states for legitimate public purpose measures, such as the prevention of price increases in electricity and energy security. In both of them, the liability of state is established in abstract form. It means if there is a radical change to a regulatory regime upon which investor has relied, then there is a breach. This is in turn raises an issue of fundamental importance in international investment law about the circumstances in which a state must compensate a foreign investor for a change to a regulatory regime when that change is not affected by any of the traditional grounds for raising a state liability under international law, such as denial of justice, discrimination, arbitrariness, or lack of due process. Philosophically speaking, it seems irrelevant to be interpreting the FET obligation as requiring the ECT states to buy back at the highest price their vested sovereign right to implement public purpose reforms. Based on these two obligations, stability and the legitimate expectation, the FET under the current ECT has become a natural incubator for international arbitration disputes for the last 8 years, and it will continue to be justified feasible solutions, and the ECT contracting parties do not take decisive action in the wider framework of the ECT modernization reforms. Otherwise, investors will bring more claims, and it even led to the withdrawal of the more ECT contracting parties, some of them such as France, Poland, Spain, Slovenia, already announced withdrawal. Yesterday, we had also update information that European Union also going to withdraw the ECT. Moreover, it could cause a regulatory chill, and the ECT contracting parties could not realize their public policy goals. Thank you. Please let me move the second provision. To reconcile a balance between two competing concepts, the dissertation substantiates that a doctrinal concept of FET should be considered from the perspective of self-contained treaty obligation agreed between contracting state parties. This is substantiated by the fact that development of FET as a lex specialis rule was created by bilateral investment treaties and the friendship commerce navigation treaties, that the incorporation of FET in international investment agreements was associated with the elimination of the uncertainty around the minimum standard treatment. The fair and equal treatment concept should be without the link to any other doctrinal concepts, sources, such as customary international law, minimum standard treatment, general principles of law, and the rule of law. Self-contained treaty obligation concept reduces the risk of expansion in interpretation. I substantiate this statement based on the following facts. Firstly, regarding a doctrinal concept and the ordinary meaning, I had to go back to the history of FET, generally in international investment law, and attempted to classify FET into one of the categories of international law sources found in Article 38.1 of the International Court of Justice Statute. The outcome of this analysis is that the construction of FET, its doctrinal concept, should be based on the assumption that it should be a conventional norm. This assumption is justified. Analysis of the theoretical background of the FET demonstrated that among academics, now consensus on the doctrinal concept, the intention of states, the ordinary meaning of the FET. Most of them inclined to the Havana Treaty, 1948, as a FET origin, but there is a considerable doubt since the Havana provision does not establish investment protection at all. I incline that origin of FET derives from the United States Friendship Commerce Navigation Treaties in the 1950s. I have analyzed the United States archives on this matter. The United States Department legal advisors incorporated fair and equitable or just and equitable treatment wordings, which supposedly took an analogy from the justiciability clauses in mixed commercial treaties in the 18th, 19th, and 20th centuries. For example, Treaty of Westminster between England and the Dutch Republic of 1674. Further incorporation of the FET in bilateral investment treaties was due to the President Truman's foreign policy called the Fair Deal. After the inauguration of the President Truman announced the foreign policy Fair Deal. My analysis supported by the Van de Velde, former United States Department legal advisor, and the Whaler's analysis. FET was included in the bilateral investment treaties during the transformation of the Friendship Commerce Navigation Treaties into bilateral investment treaties in 1950s as a treaty obligation. Supposedly, United States legal advisors tried to resolve the minimum standard treatment uncertainty through FET obligation in BITs. My finding is close to the conclusion that FET obligation generally itself a brilliant invention of the United States Department in the 1950s for the protection of United States investors abroad. In the case of the ECT, analyzed Traufax preparatory materials and the writings of academics suggested that FET under Article 10.1 was affected by the United States position. The United States took participation in ECT negotiations, but did not sign the ECT due to the conflict in positions with the European Union states. I conclude that none of other sources listed in Article 38.1 of the International Court of Justice Statute do not shed light on the FET origin. Let me focus on each of them. Regarding the relationship with the minimum standard treatment, the North American arbitral practice developed the approach that FET does not require more protection than minimum standard treatment. The United States tied FET with minimum standard treatment in their model BITs in 2004 and 2012. My conclusion is that a specific link in the treaty language between the two standards, in fact, could be problematic in a number of ways. Firstly, regarding the minimum standard treatment is itself evolving, indeterminate, and lacks clearly defined content. Minimum standard treatment was linked to early cases such as Near, Hopkins, Roberts in 1920s under the United States and the Mexico Commission. Secondly, some delicts of the minimum standard treatment and parental treatment overlap, but it is difficult to equate these two obligations. Moreover, historically, the minimum standard treatment is a product of capital exporting countries, and its existence has been challenged by many developing countries.
Mr. Kuzatov, excuse me for a second. Just a brief reminder, since you asked for 25 minutes, you have 7 minutes left. Please mind this.
Regarding the question of whether FET has become a part of the customary international law, I concluded that FET has not become a part of the customary international law. As a custom, FET has to comply with two requirements: opinion juris and the state practice. Firstly, widely concluded BITs and the incorporated FET obligation do not give rise to accepting FET as part of the customary international law. Secondly, because of lack of consensus between states, in particular, lack of opinion juris, express stipulation of the opinion juris are rarer in FET. Some of the states even excluded and do not agree on the FET obligation. Thirdly, my position is that generation of the customary international law has to conform to fundamental interests of the states. The understanding of the FET as customary international law would generate more difficulties than solution. Regarding the question of whether the FET is general principles of law or rule of law, some of the academics, such as Alexandra Dill and Yona Tudor, linked FET to general principles of law, taking into account ideas of justice and the fairness itself. At the same time, Stefan Schull explained that FET can be understood as the rule of law. I don't quite agree and suggest, even it is too risky. I substantiate that general principles of law and the rule of law are unwritten norms, wide-ranging character, recognized in states, municipal laws. FET is expressed in a number of investment agreements, therefore represents a written norm. General principles itself are playing a rather gut-feeling character. The rule of law approach is the same, even in nature, in the case of the applicability to FET. Therefore, FET should be considered independent treaty obligation. I'd like to conclude this submitted provision by saying that looking for sources of FET, we lawyers should not go too far. We should not seek a confusion in international investment law. Consequences will be long-term and devastating for states. Regarding provision 3, based on the doctrinal concept of self-contained treaty obligation, the dissertation codifies FET delicts and proposes a new construction of FET under ECT. The new construction of FET should truly reflect the meaning of FET, such as denial of justice, arbitrariness or unreasonableness, discrimination, and abusive treatment. The rationale behind this proposal is that ECT contracting parties may be held liable only for breaches of limited above set of delicts. This proposed new construction of FET increases the certainty, predictability for the ECT contracting parties, investors in the application of the FET norms. The concepts of the stability obligation and the protection of legitimate expectations should be taken out of the FET delicts, and if needed, such obligation and protection may be agreed, open or granted during individual contractual negotiations between the host state and the investor in national legislation. I substantiate this statement on the following way. I justified each of the delicts separately in the dissertation, why FET should contain them as a delict, and they explained the meaning and the practical application for each of them. Two factors were taken into during the codification. Substantiation of each delict from theoretical historical perspective, first. Second is arbitral practice in relation to the FET meaning. Also, some features specific to the energy sector were taken into account in the consideration of the FET delicts. Therefore, all of the delicts included in the FET are traditional grounds for raising a state liability under international law. It is proposed that the FET obligation should include denial of justice as a procedural fairness and as a fundamental concept in legal systems and the most venerable international wrong occupying the core of the FET. The proposed wording is based on the definitions of denial of justice from intermediate level, meaning that covers improper administration of criminal, civil, administrative justice in adjudicatory proceedings, including denial of justice to courts in adequate procedures. I posit the view that conduct of state organs or agency shall be appealed in domestic courts in due course, unless the domestic courts makes a decision on these matters. The state responsibility at the international level would not be theoretically acceptable. Arbitrariness and unreasonableness and the discrimination delicts lie at the heart of the concept of FET. Therefore, at least they ensure that investors and investments are protected against treatment by the host state, which even if not properly is acceptable because it is arbitrary, unreasonable, discriminatory, and unfair. Third, abusive treatment. To the proposing wording is a more specific emanation of the good faith element of the FET. The abusive treatment, however, delict is more specific and substantiated in practice than the good faith. The importance of this delict was recognized particularly in capital-intensive sectors and the long-term investments, such as those energy sector. Foreign investors in these sectors can particularly be vulnerable to government pressure, harassment, as the intimidation tactics. I conclude that certainty, a closed list of delicts, will help solve the problem of balance. Otherwise, tribunals will further expand the scope of FET, and the balance will not be restored. I would like to conclude the submitted provision by saying that we lawyers have already gone far away from the initial essence of the FET obligation and expanded the scope and presented FET as a catch-all clause for all circumstances of exercising regulatory rights of states. The consequences will be irreversible for states. I'd like to conclude this statement provisions with a quote. As English statesman and the philosopher Edmund Burke said, citing another English philosopher, Thomas Hobbes, law is a public conscience. Then the public conscience requires one law for all, namely that law which governs all law, the law of our Creator, the law of humanity, fairness, justice, equity, the law of nature, of nations. That is the essence of the FET obligation, nothing else.
Mr. Kuzhatov, you have now reached the 25-minute limit, so please conclude your presentation within 5 minutes. Thank you.
Between competing concepts, the dissertation proposes to integrate into the ECT the applicable right to regulate norms. After analyzing different concepts such as general exceptions, carve-outs, emerging right to regulate, dissertation proposes a strict right to regulate norms in the ECT preamble and in a separate article of the ECT which effectively safeguards the public policy measures. The proposed preamble wording is as follows: recognizing the right of contracting parties to regulate within their territories in order to meet public policy objectives, including but not limited to the protection of environment, public health, consumer rights, climate change mitigation, and energy security. The right to regulate as a separate article. For greater certainty, the bona fide exercise of the contracting parties' right to regulate within the territory to achieve public policy objectives, including but not limited to the protection of the environment, public health, consumer rights, climate change mitigation, energy security, should not be treated as a breach of the fair and equal treatment obligation. Footnote ordering, the determination of whether there is a bona fide exercise requires a case-by-case and a fact-based analysis consideration. I substantiate this wording in the following way. You may notice in chapter 2, I have analyzed various right to regulate provisions, various reservation of the regulatory space incorporated in international investment agreements would not satisfactorily safeguard the interests of states, except in cases of carve-out clauses that operate to exclude the entire sector of policy area from the scope of the international investment agreements. This dissertation proposes the incorporation of the right to regulate with a strict form that not only operates as a guard against regulatory chill, but also may limit the liability arising from the breach of FET. This dissertation therefore proposes a careful approach towards protecting the right to regulate by incorporating in the preamble too. The proposed positive preamble language does not create obligations or limit the investment protection provisions, but rather it provides the interpretive tool and the signals to tribunals the intention of the ECT contracting parties. Moreover, it means that investor protection obligations are not absolute under the ECT. This will allow striking a balance in tribunals' interpretation of the FET obligations and the right to regulate in the main ECT text. The proposed wording made a reservation of public policy areas such as environment, protection of the environment, public health, consumer rights, climate change mitigation, and energy security. All of these areas problems are discussed in this dissertation. The proposed right to regulate norms is theoretically and practically justified in the new ECT framework. Fifth provision. The dissertation proposes a new approach to the application of the proposed two competing norms, FET and the right to regulate, by hypothetically testing various public policy measures under the proposed norms. The dissertation proposes to apply the right to regulate clause as a permission norm and as a centerpiece clause of the new ECT, not a defense norm. Therefore, the right to regulate norms should limit the scope of FET. In this manner, FET deletes may be only invoked by investors when the host state improperly exercises regulatory measures. The result of the testing demonstrated that effectiveness of the proposed formulation in balancing the rights of states and investors. I substantiate this wording in the following way. Based on the proposed effective wording and the right to regulate provisions, the dissertation tested hypothetically different public policy measures under the provisions in order to examine the effectiveness of the proposal. The main idea is that application of the right to regulate provision should be a centerpiece clause in the ECT, and as the scope of FET is in essential public policy measures listed in the proposed provision. There are good reasons to view the right to regulate as permissions that limit the scope of FET rather than a defense clause that is invoked to justify what would otherwise be unlawful conduct. A state relying on the right to regulate would not deny that it had failed to observe its treaty obligation, but it would seek to avoid the consequences of its actions on the basis that it was acting to protect interests already permitted by the clause, viewed as permissionless the right to regulate signals to adjudicators and tribunals, potential claimants, that states retain regulatory capacity in the areas covered by the provision, take regulatory purpose as a central provision. More importantly, I took two ongoing arbitration disputes as an example to test under the proposed wordings. The first, Ascent Resources against Slovenia. The second is Rockcopter against Italy. In a Slovenia case, the claimant challenged the ban adopted by the Slovenia's different state bodies, which prohibited the exploitation of the oil using fracking drilling. In Rockcopter case against Italy, the claimant challenged the moratorium of the Italian government for oil exploration in environmentally sensitive area. In both of them, the respondents exercised their legitimate rights based on environmental reasons. The claimants have invoked the FET, particularly the frustration of legitimate expectations and the arbitrariness. In both of these cases, I used the proposed approach where the protection of the environment is within the scope of the reservation. Therefore, from the perspective of this approach, investors shall prove measure exercised is not in a bona fide manner every arbitrariness and reasonableness of the regulatory measure. This approach demonstrated its effectiveness and safeguarded legitimate rights. I use this approach for testing various public purpose measures such as environment, climate change, including the recent case considered in Kazakh courts regarding the breach of the environment by one of the major oil consortiums in major oil field regarding the treatment of wastewater.
Mr. Kuzatov, excuse me.
Therefore, I conclude this approach will be helpful in the application of the proposed provisions. Thank you. Let me just briefly conclude.
Within 1 minute, please.
All the provisions submitted for defense, the dissertation disclosed a number of theoretical and practical gaps in international investment law, proposed feasible approaches to fill in them. The proposed suggestions are not desirable in international law, in the international energy law, but necessary. I hope that conclusions and the recommendations made as a result of the dissertation will be widely used in practice and in theory. Of course, it is impossible to predict how the energy sector will evolve and what kind of disputes will be generated over the next 20 years. Therefore, the dissertation proposed to resolve the conflict through the adaptation and the reconsideration of the applicable provisions of the ECT in light of the emerging regulatory rights of the ECT contracting parties for sustainable development and public purposes. Speaking philosophically, the law has to respond to rapid social and economic changes, also to accelerated scientific and technical progress for the sustainability of all human life. I would like to end my speech with a quote from the British philosopher Bertrand Russell. He said that the greatest challenge to any thinker is stating the problem in a way that will allow a solution. I do believe that this research problem found a solution in this dissertation. I sincerely appreciate your attention today. Thank you very much.
Thank you very much, Mr. Kuzatov, for this highly interesting presentation. Now we will move on to the Q&A session, and let me invite the members of the Dissertation Council, the supervisors, as well as all learned colleagues present to express their views and to ask questions. And allow me to ask you the first question, Mr. Kuzatov. How exactly do you see your views and proposals implemented in the domestic legislation of the Republic of Kazakhstan in the next few years? In other words, what are your exact suggestions to be made or what are the exact amendments you are proposing to be made to the legislation of Kazakhstan as a result of your research and findings? Thank you so much.
Thank you very much, Sergey Vячеславович, for your question. You are raising a very important and very relevant question, at the same time, very difficult question, because I'm analyzing the international law, international investment law, and making the proposals to the Energy Charter Treaty. At the same time, I had a good chance to work with Kazakh government and the government bodies, which representing the ECT in modernization reforms as well, with the Minister of Energy, Minister of Justice, and the legal councils who represent the Kazakhstan International Arbitration. I would suggest that after my dissertation, I'm going to send my dissertation kind of guidance to relevant state bodies as for further implementation in practice as well. You know, in Kazakhstan we have like very investment climate is protected mostly under the contractual relationships with mostly major oil companies or major investors, and also the mostly protected under the BITs, the investors. That's why I propose to send my proposals to government bodies for implementation. My most important proposal will be the maximally excluding the stability obligation in national legislation as well, because which I almost analyzed it, that stability obligation ECT is opened doors for all investors, not for specific investors who get the stability as a result of the long negotiations with the state bodies. That's why state bodies and the national legislation makers should be careful in guaranteeing the stability or legitimate expectations for investors. That's my most important proposal. The second proposal is regarding the relationships with the investors from the perspective of the international grounds as arbitrariness, abusive treatment, discrimination. Because in government bodies, we usually face with the problems of the discrimination, abusive treatment of the foreign investors, that investors could challenge then the regulatory rights of states in arbitration. That will be my second proposal.
Thank you so much.
Also,
may I know,
Sergey Vячеславович, can I add?
Sure.
Actually, I had a good chance working with the Minister of Energy and the Vice Ministers who is representing the government in ECT modernization reforms, and the academic Maidan Kantuar Suleimanov. I submitted my proposals to them, and I had a good discussion with them, and they're proposing my new approaches and the proposals in the dissertation to Minister of Energy. Also, it's regarding the Kazakhstan. Also, I had a good discussion with other lawyers which participating in the modernization reforms, for example, from Spain. Also, very much very highly evaluated my proposals that could be useful during the modernization reforms. I believe that the proposals will be implemented in practice. Thank you very much.
Thank you so much. May I now invite my learned colleagues to ask their questions? Дамы и господа, могу я, пожалуйста, пригласить моих многоуважаемых ученых коллег задавать вопросы? I see there's a question from Dr. Tusupov. Dr. Tusupov, the floor is yours.
Thank you, Professor Yabin. Thank you, Mr. Kujatov, for your interesting defense presentation. It was very informative and very comprehensive within the given time. So very well done. I have two questions to you. You just mentioned that you've met with the various governmental officials and discussed the possibility of reform of the ECT, in particular on the standard of fair and equitable treatment. My question is, and I think you yourself mentioned before that investors, in particular in Kazakhstan, but also, I guess, everywhere in the world, are also very often protected by the BITs or sometimes the national laws on foreign investments. So to what extent your analysis and your suggestions, proposals, would also be applicable to the standard of fair and equitable treatment within the other investment instruments, first? And the second question, earlier this week, the European Commission has announced that they're proposing coordinated exit from the ECT, the European Union member states. The case law literature and commentaries have very much guided also by the opinion juries of these states. To what extent your dissertation, your analysis would change or will not change if indeed the European Union. Maybe one final comment, not a question, in terms of practicality, if indeed the European Union's member states exit the ECT and the ECT would still remain, I would imagine that your proposals and your analysis would become even more practical, just because the playing field would be much more narrower, and then the voice of Kazakhstan, among other states, would still remain, hopefully, within the ECT. Well, not hopefully, not expressing any opinions here, but the practicality and maybe the value of the dissertation would hopefully increase. Just a comment. So the two questions are yours. Thank you.
Thank you very much. Dr. Alibek, regarding the first question, I didn't quite catch. You are asking how this FET obligation will be implemented within other BITs?
My question was how your analysis, your scientific work would also apply, including the proposals, would also apply to the FET standard, which is enshrined in other investment instruments. And the context of the question was that you were meeting with other governmental officials, suggesting certain of your ideas in terms of reform of the ECT, and if this analysis can also be used for other instruments, then why not use it? And if you see the prospects in this.
Thank you very much, Dr. Alibek. Thank you for important and relevant question regarding your first question. Of course, FET is a kind of widespread obligation in treaties, and it will be easily implemented in other bilateral investment treaties. If, for example, Energy Conference will accept my proposal and included it in the ECT text, then other BITs, of course, could copy or, as an example, use this FET obligation in other BITs. In Kazakhstan, from the Kazakhstan perspective, the Ministry of Foreign Affairs is dealing with these BITs, the Ministry of Justice. As I said that I'm planning to submit my dissertation to these governing bodies, which could be used by the state bodies in negotiations of the bilateral investment treaties in future. Did I answer your question, first question?
Sure.
Thank you. Regarding the second question, regarding the European Union's exit from the European Union, It's a very interesting question. Also, I'm very nervous that European Union will leave this ECT modernization, because all of the major countries as France, Germany, Spain announced their withdrawal, Netherlands as well, from the ECT negotiation. It is actually too risky for future of the ECT, because the European Union is the main partner and to the ECT. The main aim of the ECT actually at the first time when it was signed was long-term cooperation in the energy sector between the European Union and the former Soviet Union states, because former Soviet Union, European Union was interested in the oil and the gas fields of the former Soviet Union states, such as Kazakhstan. That's why if European Union will leave the ECT, it could be too risky. Actually, the principal agreement on ECT modernization reforms was achieved in June the last year, but in November the last year, ECT conference wanted to sign the pre-agreement ECT modernization reforms, but failed due to the European Union's position. The European Union's position is regarding the excluding the fossil fuels, the oil and the gas, from the scope of the investment protection provisions of the ECT, as well regarding the application of the investment protection provisions to clean energy sector. That's the main problem. And I think that if European Union will leave the ECT, it could be more harmful for parties. But of course, since that 53 countries is party to the ECT will be alive because many of the states are already party. That's why I hope that this year consensus will be achieved between contracting parties. I hope that like open questions which affecting on the conclusion of this modernization reforms will be solved finally, and the consensus will be. Thank you.
Thank you very much. May I now invite Dr. Young of the University of Leicester to ask his questions, and then we will proceed to questions from the offline audience. Thank you so much.
So thank you so much to the speaker as well as Dr. Sayapin. So I also have two questions. So the first question is, so on page 11 of your thesis, so you explained that so you have many years of work experience in the oil and gas sector of Kazakhstan, including representing the government of Kazakhstan in international investment and commercial arbitration and negotiations. So I think it's good to have the practical experience, but just want to ask you, so from your own practical experience, so what are the problems and challenges faced by the companies and the government? So so you can share some of your own experience. So this is my first question. And then my second question is, so obviously the motivation of your research is to restore the balance between regulatory rights and investor protection. So I want you to explain further the nature of this imbalance. For example, because in your presentation earlier, you show us some statistics because you said that you identified 157 arbitration cases. And out of these 157 arbitration cases, I think you said that, so among which 44 among them, so in 44 cases, so breaches were identified. So does data like this reflect the imbalance that you set in the thesis? So these are my two questions. Thank you.
Thank you very much, Dr. Regarding the, I'm sorry that there is a kind of problem with, from the speaker, from the voice. That's why, regarding the first question, you mentioned that I didn't catch exactly your question. Could you please repeat just your questions, the first question?
So, because you said that, so you were involved in different international investment, commercial arbitrations and negotiations. So from your own practical experience, so what are the major problems and challenges faced by the oil companies as well as the governments?
Okay. Thank you very much. Thank you very much for your question. Regarding the first question, FET, of course, is not only a problem in practice. There are a lot of problems which investors and states are facing in practice. For example, taking from my experience, I'm working over the 10 years in representing the Kazakhstan in oil and gas, major oil and gas projects. Most of, from our perspective, for example, Kazakhstan's perspective as a government worker, we usually face the problem of the stability obligations which we guaranteed to investors in 1990s, because after the independence of the Kazakhstan, we have signed several major contractual contracts with major oil companies. That is the main, and we have provided a guarantee for companies regarding the stability of the national legislation, regarding the stability of the contract. And there are, almost 25 years, 30 years is going ahead, and there are problems in implementing some of the regulatory measures, such as environment, such as the public health, such as the problems which, for example, the taxation as well, which stabilized under the contractual relationships. It is very difficult from state perspective to implement such measures in relation to these big oil companies. If we will look from the perspective of the investors, because I also work as a consultant on the other side, the problem also with the national legislation, inconsistencies on application of the legislation. There are many problems which investors are facing as well. It is mostly they are raising kind of questions, problems regarding the taxation of the international oil companies. Environmental matter is very tricky matter between the states and investors. Also, public health, which I provided in the dissertation, some of the examples which investors facing. Also, the exchange control. I mean the change of the currency, devaluation, etc., also affecting on the investor side. All of them is regarding the stability from the investor side in host states. That is the main problems and the challenges which state and investor are interacting and trying to solve. Did I answer your question, or you are going to ask that what are the problems in international investment law than FET? You mean, for example, expropriation disputes?
So my second question is in relation to
Okay.
the
No, I can use
imbalance.
the second question if you want.
Yeah, imbalance.
Yeah, regarding the balance, you know, I had a good discussion with Professor Noel Gallagher from the Queen Mary University of London. She said that I have analyzed the tens of ECT cases and there is no breach of the balance. And she wrote the article about it. And we had a good discussion with her. But I justified the opposite, you know, the stability and the legitimate expectations, which are not part of the FET, actually breached this balance in the, you know, providing the stability for all investors, which, you know, like treated by the host state during the modification of the national legislation. If you see, I provided the examples, the liability in these cases established in the abstract form. You know, the point is, for example, if you see, for example, just a second. If regulatory, you know, changes happens and it will affect on the investor's profit or revenue, the investor claims this profit to state, you know, state to buy back his sovereign right at the highest price. You know, state has a regulatory chill. That is a breach of the balance. You know, state bodies are thinking twice before making a decision in relation to the investors, because they have a regulatory chill. Will they breach the FET or not? Will we breach a stability obligation or not? That's the main problem of the balance. That's why all my dissertation, which I justified my position, is the exclusion of the stability and the legitimate expectations from the FET scope. I did it, and I have not only like theoretical foundations, but I have also facts. For example, sorry for answering you more detail regarding the legitimate expectations. United States invented this FET obligation, but United States in other cases saying that the legitimate expectations is not a part of the FET. But other part of the world is accepted legitimate expectations as part of the FET and the stability obligation. It's a nonsense. Did I answer your question?
Yes, yes. Thank you so much.
Thank you very much.
Thank you. Before we proceed to questions from the offline audience, may I ask Professor Sabahi if you have any questions for the candidate at this time? In the next section, I will ask you to make your comments about the thesis, but do you have any questions for the candidate now?
Thank you very much, Professor Sayapin. At this time, I think I will reserve my comments for later. In a way, Professor Adelbach's question somehow covered what I wanted to ask, because that was a way looking forward, and Baghdad addressed it. So for now, I wait.
Thank you so much. Then we'll proceed to questions from the offline audience. Уважаемые коллеги, давайте теперь перейдем к вопросам в аудитории. И поскольку я через камеру не очень хорошо вижу, кто поднимает руки, позвольте я приглашу профессора Идрышеву задать свой вопрос, а потом я попрошу вас, Сара Кимадиевна, посмотреть в аудитории, у кого еще есть вопросы, и модерировать эту часть нашего заседания. Спасибо.
my dissertation on the problems of the energy sector treaty. And already then studied the energy charter treaty. Of the past 20 years, we have not had dissertation on energy supply or on the EEC treaty. Therefore, this topic is very relevant. Super.
Thank you.
And I have a question. The energy charter treaty is directly related to the economy of Kazakhstan. In this regard, what is your opinion? Is your currently a formal interpretation? Are you proposing interpretation of this treaty?
Thank you very much for your question.
Я
I
прощения для тех, кто, может, не совсем понял мой английский с акцентом. Я хотела сказать, что много лет назад, более 20 лет назад, я защищала диссертацию первую тему права и правового снабжения. Впервые в 1995 году была принята договор коммунистической хартии. Мне пришлось долго искать этот текст, я не могла его найти, потому что право и правового снабжения, сами понимаете. Вот. И вот с тех пор так получилось с докторантом, что у нас с ним имеется общая тема, по которой я могла, скажем так, объективно оценить то, что ты написал. Ну и поэтому не хочется знать, что за 20 лет произошло. Правительство наше на том же уровне, как было 20 лет назад, что ему все равно было, я не понимала значения никаких проблем, не было международные, договор-коммунистической хартии. И вот хотелось бы услышать как раз от вас ответ, вот, как вы думаете, ваше мнение, вы тоже изучали, наше правительство все-таки немножко критично относится к этому договору, или вперед говорит, да, правильно. Или ваши замечания конкретизируют политики нашего правительства. Спасибо. Thank you.
Thank you for the question. You're asking a very important question. Regarding the which signed in 1994, Kazakh government was actively participated in these negotiations. But in the modernization of the city, unfortunately, Kazakh government, represented by the Minister of Energy, was passive in participation. Academic Maydan Kuntuarov Suleimanov is taking part in this modernization from the Kazakh government. Minister of Energy presented as a participant. I think that since that modernization of the ECT concluded by ECT conference, 53 countries, and the modernization reforms almost is like going 5 years from 2017, and they still continue. That's why there are like a lot of hot discussions on this modernization reform. I believe that most likely Kazakh government will accept the interpretation of other countries, particularly the European Union text, because in the current text of the ECT draft is mostly drafted based on the European Union model treaties with some modifications. For example, the Maydan Kuntuarov Suleimanov wrote his recommendation letter, and he wrote about that regarding the legitimate expectation belief. Initially, this belief was excluded from the scope of FED, for example. Then after the several discussions, some of the states insisted to include the legitimate expectations. That's why number of other countries is going to accept legitimate expectations as a delete of the FET. That's why I believe that the Kazakh government will accept the consensus-based ECT text. Thank you. Did I answer your question?
Once you ask a question.
Yeah, thank you.
Thank
you. On page 62, you mentioned that in the interpretation of FET under VCLT Article 32 did not succeed because of Trevo preparators as held on that matter. If we analyze Article 32 VCLT, we can find that we must possible result have as an ambiguous meaning or an absolute result. That's why the question is, do we have ambiguous meaning or absolute result regarding FET interpretation? And the question secondly is, in case of tribunals recognize FET as a customer law, do you think this would lead to automatically recognizing FET as customer law?
Okay. Thank you very much for your question. You're asking very material questions regarding my dissertation. Regarding the first question, interpretation of the FET was actually very difficult. One of the toughest challenges for tribunals, because under Article 31, tribunals refer to the ordinary meaning. Ordinary meaning, if you look back to the, for example, commentary to the VCLT by the Dr. Gilliger, says that ordinary meaning will be given by the states, but there is no ordinary meaning which given by the states, contracting parties. That's why, as academic Salakius commented, that ordinary meaning of the FET is almost vague. That's why tribunals went back to the object and the purpose approach, which also more restrictive approach, as Dr. Gilliger said, could not fully describe and interpret the treaty obligation. That's why tribunals tried to refer to the Article 32 regarding the Trophos preparatories, but there is no way regarding the Trophos preparatories, because compare with, for example, the exit documents, institution documents, there is very problem with the Trophos preparators of the bilateral investment treaties and the ECT documents. There is now kind of detailed chronology and archives on ECT. I have looked at the ECT archives which existing, and I tried to find some early drafts regarding the FET interpretation, and I tried to use that could be useful for the interpretation of the FET under Article 32. But as I said, tribunals could not achieve the way on this. That's why tribunals refer to the object and the purpose, which object on the purpose of the Energy Charter Treaty and the European Energy Charter objectives were mostly saying that states shall provide stability and the long-term cooperation in the energy sector. Tribunals referring to these objectives of the European Energy Charter try to interpret FET as more like providing the stable and the predictable framework. Regarding, did I answer your question? The second question. Can you please, if you don't mind?
My second question was, in case of tribunals to recognize FET, what do you think automatically would lead to the transformation FET into customary law?
No. First, because as I said, in order to be customary law, two components shall be satisfied, is that injurious state practice. If you look Article 38.1 of the Court of Justice Statute, saying that international customs as evidence of general practice, it's a more objective element, general practice, it's a state practice. The second is accepted as law, it's like not subject and injurious. That's why the decisions of the tribunals are not qualified or specified as customary. But there are some thoughts about saying that conclusion of the BITs and inclusion of the FET in BITs, like widespread inclusion of the FET in BITs, will raise the customary international character of the FET. What I don't quite agree with, for example, Yonah Tudor has positioned that FET has become a customary law based on the state practice without appeal. Like saying some of the BITs include FET, some of them not. That's why between states there is no consensus whether FET should include BITs or not. That's why my position is that in the future it is less likely that FET has become a customary international law. But the second point regarding the minimum standard treatment. Minimum standard treatment supposedly saying that has become the customary international law. Then the United States and North American practice equated the FET to that's why saying that based on the standard treatment, FET is going to be like customary law. But it is also like considerable doubt from theoretical point of that FET has become a customary international law. Thank you.
And who has a question? Сергей Вячеславович, тогда слово берите. Вопросы уже нет в аудитории.
Больше вопросов нет, я правильно понимаю? Dear colleagues, thank you. It seems there are no more questions either online or offline, and therefore, with your permission, we can move on to the next section of our session. Now let me invite the esteemed supervisors of the candidate to express their views on his work and the thesis. May I invite the main supervisor, Dr. Zangar Maksutovich Nogaybai, to kindly express his views on the work of Mr. Kuzhatov.
Спасибо, Сергей Вячеславович. Приветствую, уважаемые коллеги. Since we are holding this meeting in English, I will continue in English. Dear Honorable Chair, members of the Dissertation Council, the participants, all, good afternoon. My name is Zangar Nogaybai. I am counsel of White & Case. This is an international law firm based in Astana. I am based in Astana. I received my doctorate degree from Berlin University in Germany. I've acted as supervisor for Baghdad from the beginning of his research work. Sorry. I've acted as a supervisor for Baghdad from the beginning of his research work. I provided all academic guidance, supervision work, and support in reviewing and commenting on various drafts of his dissertation from the beginning. The research was completed relatively in a short time, within 3.5 years, for such a complex topic. My main comments will be as follows. First and foremost, it's worth mentioning at an early stage of the research, Baghdad involves leading international experts in the field of international investment law and international energy law, such as Professor Peter Cameron, whom I also personally know from Dundee University, and Laura Gallagher from the Queen Mary University of London to provide guidance of this complex research topic. At a later stage, as an international advisor, joined Professor Borsu Sabahi from Georgetown University, US, a leading professional in the field of international investment arbitration. Professor Borsu Sabahi has significantly contributed to the structure of dissertation and substantiation of argument from international investment arbitration practice. I would like to personally express my sincere gratitude and acknowledgement to Professor Dr. Borsu Sabahi. Moreover, Baghdad was in contact with Spanish lawyers who represented Spain in several arbitration disputes on this research problem. For example, Mr. Rafael Gil Nieves, former Deputy Head of Arbitration Department of the Ministry of Justice of Spain. Further, during the substantiation of his proposal regarding the right to regulate provisions, Baghdad relied on Saguka versus Czech Republic award. He communicated and had a good discussion with the legal counsel, Mr. George von Meckler from Squire Patton, who represented the Czech Republic in this case. After completion, it is a great honor that Mr. George von Meckler found time and reviewed this dissertation. As a result, he provided a recommendation letter in support of Baghdad's proposals. Therefore, I think dissertation work of Baghdad is verified and completed with coordination of leading international subject matter experts. As one kind of evidence could be mentioned that he published article in Scopus 1 quartile prestigious international journal Energy Policy. Moreover, Baghdad sent his dissertation to well-known Kazakh academics for verification and independent review. Kazakh academics such as Maydan Kuntuari Suleymenov, Gulash Muratovna Ilyasova, Guljalkhar Tursunxanovna Kaziyeva provided their feedbacks as well. And I probably should also mention that, as you know, Maydan Kuntuari Suleymenov took part in ECT negotiation during 1992-1994, as well as he is now taking part in modernization reforms of ECT during 2007. He positively commented on this dissertation work, even though he didn't hide his emotions that Baghdad's work is probably strongest research work he has read in the last 10 years in Kazakhstan. The chosen topic for PhD dissertation is complex and controversial in international investment law. Specifically, the topic has obtained considerable importance in light of massive arbitration claims against countries for alleged breach of stability obligation and frustration of legitimate expectations for measure aimed at protection of environment and transition to clean energy. This topic has importance for Kazakhstan as well, since Kazakhstan is a member of ECT from the beginning of 1990s and one of beneficiaries of ECT2. Baghdad dealt with Kazakhstan's regulatory framework and made a number of proposals to defend Kazakhstan's national interests in framework of ECT, as well as it could be used in negotiation of other international investment treaties. Therefore, I think the chosen topic by Mr. Kuzatov is timely and relevant from all aspects. Third, I highly value that Mr. Kuzatov has conducted a an in-depth analysis on historical origins of competing interests between regulatory measure and investment protection in energy sector, current norms of Article 10 of Energy Charter Treaty to identify the lack of balance between emerging regulatory measure of contracting parties, the states, and investment protection under the fair and equitable treatment standard in Chapter 2. Various wordings of the FED standard in different international investment agreements for comparison with the Energy Charter Treaty wordings. Various reservations of right to regulate clauses in Chapter 2. And on the new proposed wording of FED standard and its practical application in Chapter 3 of this dissertation. Mr. Kuzatov has done independent scientific research, applies a solid methodology and detailed outline, and has managed to execute and address the relevant topics. During his research, Mr. Kuzatov analyzed a large number of decisions of international arbitral tribunals and contribution on the leading academies on this topic to achieve the objectives of the research. Conducted research work is a valuable contribution to the number of theoretical discussions around the FED standard, particularly the balancing issue between investment protection and regulatory rights. The research work could be used as practical guidance material for government bodies, investors, and practicing lawyers concerning the scope of FED standard and emergence regulatory measure. His dissertation complies with, I think his dissertation complies with all the requirements of Kazakh Ministry of Science and Higher Education set forth PhD dissertations. It's important to note that Baghdad is a practicing lawyer and head of arbitration department at PSA Kazakh Government Authority in major oil and gas fields of Kazakhstan. He represents Kazakh government in complex international investment and commercial arbitration disputes on multi-billion claims. Based on above, I believe that Baghdad truly deserves a PhD degree in law. And I kindly ask for dissertation council chair and members to support him as his dissertation work. Many thanks for your time. Я хотел бы еще добавить, что эта тема очень-очень сложная. И эта диссертация, она имеет практическую и научную ценность. Как практик, я уже несколько раз ее использовал в своей работе для понимания отдельных арбитражных решений, отдельных аспектов этой нормы ФЭД-стандарта. А научная ее ценность в том, что в ней заложено очень много своих мыслей, и с ними можно соглашаться или не соглашаться, но важно то, что именно у нас в Казахстане будет формироваться своя научная школа, и по этой сложной проблематике, по которой практически нет монографических исследований в мире. Спасибо за внимание. Thank you very much, dear colleagues.
Спасибо большое, Зангар Максутович. Thank you very much, Dr. Nogaybai. And now it is my pleasure to give the floor to Professor Borzu Sabahi to express his views on the work of the candidate. Thank you very much.
Thank you very much, Professor Sayapin. Hello, everyone. And my name is Borzu Sabahi. I'm a professor adjunct at Georgetown University and a partner at the law firm of Curtis Malay. I first express my gratitude for involving me in this exciting project. It has been a journey that I have tremendously enjoyed it, working with Baghdad, and I very much express also my gratitude to Professor Zangar Nogaybai for his kind word. The pleasure has been certainly mine, even though I have been working since 2001 with Baghdad. It seems to have been a long time because we did a lot of work together and alone. What I observed at that time when I essentially joined the advisory as an international advisor to Baghdad was that he has chosen a topic, he had done a lot of research, And it was just the idea of taking the project to the kind of a next step. So I discussed with him various ways how could he essentially contribute something practical given his background and his practical experience, because Baghdad is not someone who has essentially not seen the real world. I mean, he has been working on real cases, negotiated contracts, etc. And I thought that experience needs to be put into good use. And that kind of, in a way, reshaped or help his methodology and outline of the work to evolve into something that, while commenting theoretically on what is the origin of FET in international law, what is the origin of FET provision within the ECT, and what were the political dynamics at the time that the old ECT was negotiated in the 90s, and what are the concerns of the international community today, and that's how the modern concern should inform the interpretation of FET under ECT, and what is it that the position of the Kazakhstan and many other countries that they need to export fossil fuels and to be kind of protected, but in the meantime also we have all of these concerns about environment. So Baghdad has its own strong and views of, yeah, we have to achieve both. We have to achieve both, and we need to protect modern consent, environment, sustainable development, as well as we need to continue essentially doing the essentially extraction in a more environmentally friendly manner. His suggestion was the essentially a more robust exception to the FET, and to kind of preserve their right to regulate. And that is very actually, in my view, interesting, particularly in the difficult context today that many of the Europeans want to pull out of the agreement, because that kind of Baghdad's, I think, perspective is pretty much the only way to try to strike a balance, and as he has put it in the subject matter of the BAT, between the rights that particularly Europeans have been very much vocal about protecting, as well as the interest of those who want to export the fossil fuels. So I think he has made very good research. His dissertation went through numerous drafts, and we reviewed it. I reviewed it alone together with him and challenged his ideas. I think the questions today from the floor as well as online are a testimony to the thought-provoking issues that he has brought up and the importance of them. For pretty much the whole world community. I think one of the questions that came earlier from, I think it was from Professor Adelbach about the future of the ECT and how this Baghdad's proposal may interact with other bids. I think that was pretty apt, because this essentially proposed model, to the extent that helps the states really preserve environment and in the meantime protect investment, could end up in future treaties, or could even as some sort of a doctrinal work influence interpretation of existing bids with tribunals, if to the extent that they think that the right to regulate is an inherent part of the doctrines of international law. And so all of that is very valuable. For Kazakhstan, I think the last part of the dissertation is very important, because Baghdad is drawing on his own personal experience. He's testing the formulation of the provision, the exception that he has crafted, and he wants to see what difference in practice that makes. If you have that clause with the exception that Baghdad has proposed, maybe a number, the dynamics in the domestic law system, etc., in terms of dealing with situations that would involve protection of environment versus kind of interest of an oil company would be dealt with differently. How different? That's something that really has to be tested. You know, it's just a matter of the drastic change. Obviously, is kind of something that maybe sometimes is not good, but it will definitely leave some impact, and its incremental effect in the long term would be very important. So I did not want to repeat what Professor Nogay said. I fully agree with his comments. I just wanted to give a different perspective about some of the more substantive issues. And with that remark, I fully think Baghdad has worked hard, and he has tried to involve a number of international experts. That's, I think that is ambitious. The subject matter of his dissertation has been ambitious on its own. And I think that's brave. In a way, it's scary, you know, to get all of these experts involved, bring them and let them judge you. And but I think he has he has something to offer and has worked hard for it. And I think he needs to get essentially I propose to be approved subject to the discussions. At least I am very happy with what he has accomplished so far. That is my personal perspective. And I stop here. Thank you for the floor.
Thank you so much, Professor Sabahi. Now, dear colleagues, with your permission, let us proceed to the next section, and let me give the floor to the official reviewers to express their views on the thesis. Now let me invite the first reviewer, Kasim Sirbayevich Maulenov. Sir, the floor is yours.
Good afternoon, dear Honorable Chair and members of the Dissertation Council, our university, dear participants, dear all colleagues. Firstly, it's really great pleasure to me to participate today in the public defense of PhD dissertation by doctoral student Bагдата Gizzatовича. And really, today is an international council from different countries in the world, United States, European and other regions, and Kazakhstan. Secondly, I appreciate that Dissertation Council appointed me as an official reviewer for this submitted dissertation. I have experience in the practice when I worked in the beginning of 1990s in the Ministry of Foreign Economic Relations for the Republic of Kazakhstan in the position of Head of Legal Treaty Department and in the position of Legal Advisor of Staff Office of President of our country. And it was really good experience to prepare new legislation in Kazakhstan and international treaties. One of the sector of my activity, it was investment policy in Kazakhstan and bilateral and multilateral investment treaties. I prepared my doctoral dissertation in 2001 by topic State Management and Legal Regulation in the field of foreign investment in the Republic of Kazakhstan. And really, this topic is very interesting to me. First of all, I tell about officially provided my writing feedback to PhD dissertation by Bагдата Гиззатовича, and according to the approved form, the Minister of Science and Higher Education. Please let me briefly describe them. The topic of the dissertation completely corresponds to the priority direction of the development of science for 2021 and 2023, approved by Higher Scientific and Technical Commission, and as the main text of legal policy of the Republic of Kazakhstan until 2030, approved by President Decree of the Republic. Dissertation has a significant contribution to the development of international investment law, international energy law, and modern investment treaty regimes. Its importance is well disclosed in the dissertation in light of shifts in modern investment regimes. The principle of independence of writing is high. The relevance of the chosen topic is well justified in the dissertation. In particular, dissertation consists of 3 chapters and number of sub-chapters that well reflects and disclose the dissertation topic. The purpose and objectives correspondent comply with the topic of the dissertation. All chapters and sub-chapters are fully and logically interconnected. Also critically analyzed over 100 decisions of arbitration tribunals, and all papers of well-known international academic and made his own conclusion and interpretation of problematic doctrinal issues of the fair and equitable treatment and the right to regulate. Scientific results and statements are completely new. All key findings are based on scientifically sound evidence and are reasonable, well-founded. My comments regarding basic provision for defense. Bагдата Кужатов submit 5 provisions for defense. All of them are proven, not trivial, new, and have a wide publication. One of publication, Bагдата Кужатов, in a Scopus publication. It's really very important to doctor dissertation. 4 of them are proven in the articles. One is not. The choice of the 4 methods is well justified. The results of the dissertation work were obtained using modern methods of scientific research and methods of the processing. Important statements are well supported by references to reliable scientific literature, including literature of well-known international and national academics, as well as decision of arbitration tribunals and separate opinions of arbitrators. Used literature sources are sufficient, and literature sources contain 438 references. It's really all literature is new and published in the last period of time in 2020 and 2022. Dissertation has theoretical and practical value. The author raised a number of fundamental theoretical problems and solid proposals for these problems. It is important to note that the dissertation is a practical importance and there is a high probability of applying the results obtained in practice. The suggestions are completely new. The quality of academic writing is high and the dissertation is written in an academic style. My general comments are also made a good comparative analysis of two case studies on the regulatory framework of the European Union and Kazakhstan. However, they also put more emphasis on the European Union states framework, such as Spain, Italy, and France. Some recommendation. First of all, it will be good if the author a bit more makes references to Kazakhstan authors who also specialize in the renewable energy sector. Also, it will be good if the author provides general suggestions for Kazakhstan government bodies on how Kazakhstan should take a policy approach to future bilateral and multilateral investment treaties in general. Today we tell about, first of all, bilateral investment treaties, and in the history of investment relations in the world, we tell about model bilateral investment agreements, model bilateral investment treaties. We tell about first bilateral investment treaty between Germany and Pakistan, adopted in 1959 year. Then in Germany adopt special model bilateral investment treaty in 1998 and 2080. We tell about model bilateral investment treaty in Austria, adopted in 2080 year. We tell about model investment bilateral treaties United States, and it's adopted in 1994, 1998, 2004, and 2012. And we tell about different other countries' experience. For example, India adopted model bilateral investment treaty in 2003 and 2015. I have a question: why Republic of Kazakhstan started to have experience in the 2092 year when we adopt first bilateral investment treaties with Turkey, USA, Great Britain, Germany, China. We don't have our Kazakh model of bilateral investment treaty. This is really important because we talk about guarantee interest of the state Republic of Kazakhstan. Second, by my opinion, it's very important regional cooperation in the sphere of foreign investment. In the practice of Commonwealth independent state, we signed in the 1993 year agreement, multilateral investment treaty, CS countries. Then in 2008, we have special agreement, multilateral agreement between Eurasian economic cooperation countries. And in the world, we tell about experience different countries. For example, we tell about Arabian countries' experience. They sign agreement, treaty in the sphere of investment policy, and it's began from 1980 year. Really, this is important to Republic of Kazakhstan, and we tell about very important regional cooperation. By my opinion, in the future in Kazakhstan, we come back to special legislation in the sphere of foreign investment. Why? Because today rules about investment policy and foreign investment policy include in the entrepreneurial code Republic of Kazakhstan. But before, start from 1990, we adopt special law about foreign investment. And really, Kazakhstan was number first in this period. It was period of former USSR. By my opinion, it's really, I recommend publishing dissertation Багдат Гиззатович Кужатов by monographs in a foreign publishing house in English, and in the Republic of Kazakhstan, it's important publishing his dissertation in the Kazakh and Russian language. In conclusion, taking into account the above comments, I strongly believe that the dissertation of Kuzhatov Bагдат Гиззатович on the topic revision of balance between regulatory rights and investment protection under fair of equitable treatment, the Energy Charter Treaty framework is highly relevant and important, as well as the provision submitted for defense have a scientific value. His insignificant proposals for revision for fair and equitable treatment and his demonstration of how they would have applied both in past cases and from his own experience representing the Republic of Kazakhstan in international arbitration disputes. The proposals are extremely well developed and present what I believe are appropriate solutions to the inherent conflict between investment protection and the right to regulate in the Energy Charter Treaty framework. By my opinion, to conclude, Багдат Гиззатович Кужатов truly deserves a PhD degree in a specialty law. Thank you very much for your attention, dear colleagues.
Thank you very much, Professor Maulenov, for your very valued comments. Now let me invite the second reviewer, Nazgul Sabirovna Tuyakbaeva, to present her comments. May I also ask the reviewers to please limit their comments to 10 minutes. Thank you very much.
Thank you very much for your participants. I would like to say good afternoon to the all honorable chair and members of the Dissertation Council. So it is my pleasure to participate in today's defense of the PhD dissertation by doctoral students Bагдат Kuzhatov, who actually began his law education at the Al-Farabi Kazakh National University. And I'm so proud of him to see he's today who defends his PhD doctoral work. So thank you also, Dissertation Council, for your appointment me as an official reviewer for the submitted dissertation. And I would like to say that several years ago, my colleagues and I, we actually conducted fundamental research work on the topic related to the using alternative type of energy in Kazakhstan, how we can regulate it. And additionally, when I was studying at Duke University, I actually had classes related to the international conventions in energy law. So that's why I was very interested in when I saw the first time Bагдат's dissertation work. So I have officially provided my written feedback to the PhD dissertation of Bагдат Kuzhatov according to the approved form of the Ministry of Science and Higher Education. According to this form, I have several sections related to his work. So please let me briefly describe the comments I made in the written feedback. The first one is the topic of the dissertation completely corresponds to the main objectives of the concept of legal policy of the Republic of Kazakhstan until 2030. The priority directions of the development of science for 2021-2023 approved by the highest scientific and technical commission. And the strategy of Kazakhstan 2050, a new political course. This is a main completely correspondence. The second section is significance of science. So the dissertation makes a valuable contribution to the development of international investment law, treaty law, also international energy law in light of the shift from traditional fossil fuels to renewable sustainable development. So significance is well disclosed in the dissertation. The third section is the principle of independence. So the principle of independence of writing is high. The author provided a self-analysis of hundreds of awards of investment arbitration tribunals, also Trevor's preparatory materials of the ECT and US treatises and books and articles of well-known international academics. The author made self-conclusions and interpretations on each interpretation problem related to FET under Article 10, subsection 1 of the ECT. The first section is the principle of internal unity. So the relevance of the chosen topic is completely justified in the dissertation. Particularly, the dissertation consists of 3 chapters and several subchapters which completely reflect and undercover dissertation topic. The purpose and objectives of the dissertation fully comply with the topic of the dissertation. All chapters and subchapters of the chapters are fully and logically interconnected. The 5th section is the principle of scientific novelty. I would say the scientific results and statements are completely new. The next section is substantiation of the main conclusion. So all key findings are based on scientifically sound evidence and are reasonably well founded. This next section in the feedback is the main provisions submitted for defense. So my comments regarding basic provisions for defense that Bагдат Кужатов, submitted 5 provisions for defense. All of them are: first, proven; second, not trivial; third, new; 4, have a wide application; and 5th, 4 of them are proven in the articles which are shown in this feedback. The principle of certainty, reliability of sources and information provided. So the choice of all 4 methods is well justified. The results of the dissertation work were obtained using modern methods of scientific research and methods of processing. Important statements are well supported by references to reliable scientific literature, including the literature of well-known international and national academics, as well as decisions of arbitration tribunals and separate opinions of arbitrations. Additionally, used literature sources are sufficient. Literature sources contain 438 references. The 9th section is the principle of practical value. So as we can see that the dissertation has theoretical and practical importance, because the author elevated several main theoretical scientific problems in international investment law. The author also provides practical solutions for these problems. The dissertation has practical importance and there is a high probability of applying the results obtained in practice. The suggestions are completely new. And the last section of my written feedback is the quality of writing and design. So the quality of academic writing is high and the dissertation is written in an academic style, and despite that the author is not actually a native speaker. However, I would like to emphasize that Bагдат Кужатов showed very high standards of academic writing skills. And in general, I would like to say about his work that some comments. Its first one is, it would be good if the author makes a more specific analysis of the risk of Kazakhstan's regulatory regime on renewable energy, as the same he did on the European Union states. In particular, is a regulatory framework of Kazakhstan on renewable energy and the risk of investment claims. The second one, it could be more out of the dissertation topic because he raised the FET issue under the ECT. But my suggestion is it would be valuable if he takes the point in the future if he wants to publish a monograph after his dissertation. Because I would say, like, for example, at Kazakh National University, we have the special educational program related to maritime and the energy law. And sometimes we couldn't find really good books or monographs. And it will be very good if he will publish his work as a book. In conclusion, I would say that this remark is a more technical and advisory in nature. Therefore, they should not impact the conclusions and provisions submitted for defense. Considering the above feedback and substantiation, I conclude that the PhD dissertation of Kужатова Багдата Гиззатовича for the topic revision of balance between regulatory rights and investment protection and the fair and equitable treatment, the Energy Charter Treaty Framework, is extremely relevant and important conducted research in international investment law, and the provisions submitted for defense have a significant scientific value. Baghdad has done independent scientific research, has applied a robust methodology and a thorough outline, and has managed to execute and address the relevant topics with a significant amount of research and analysis. This PhD dissertation deals with a very important and timely issue and contributes to the current debate on the balance between investment protection and the right to regulate in the ECT context and generally in international investment law. That's why I believe that Baghdad deserves a PhD degree in AD 04201 law educational program. This is my written feedback, and thank you for your time, and thank you for paying attention on my feedback. Thank you so much.
Thank you very much, Nazgul Sabirovna, for your very valued comments. And now let me invite the candidate to kindly respond to the comments made by official reviewers. Mr. Kuzhatov, the floor is yours.
Thank you very much, Professor Serbayevich. Thank you very much, Nazgul Sabirovna. I appreciate that you related my dissertation work high level positively. Many thanks. Regarding your recommendations, the first recommendation or comment of the Professor Serbayevich regarding the analysis in the renewable energy sector of the Kazakhstan. Yes, I did quite a lot of analysis on European Union states regulatory work, because the balance issue is appeared in the European Union states due to the transition from fossil fuels to clean energy and in compliance with the Paris Agreement 2015. That's why I mostly focused on the EU regulatory framework, like disclosing the problems of the balance issue. Regarding the Kazakhstan, since I'm writing the dissertation in Kazakhstan, I also included the case study of the regulatory framework of Kazakhstan. But in Kazakhstan, this problem is not so quite big, since regulatory framework on clean energy is now still under development in Kazakhstan, and trying to transmit the regulatory framework of the European Union to Kazakhstan. That's why the dissertation maybe will be good for Kazakhstan, since taking into account the challenges which happened in European Union regarding the transition from fossil fuels to clean energy. Of course, you correctly noted these points, and despite that, in Kazakhstan, that renewable energy sector is still developing, and many of the regulatory acts have been already acted, but in the future will be if I'll publish a monography, I of course will take into account the Kazakh academics on this matter. Thank you for your question. Regarding the BITs, model BITs, maybe unfortunately, maybe fortunately, in Kazakhstan we don't have the model BIT. Usually, Kazakh government accept the model BITs of the contracting states. I personally have been participated in 2016 in BIT negotiations with China. Kazakh government accepted the Chinese BIT and tried to protect their interests in this BIT. Of course, in my opinion, we certainly need a model BIT that will protect the public interests of the republic and the essential interests of the republic in this BIT. Hope that maybe Minister of Justice and Minister of Foreign Affairs will take this point and in future will be model BITs, and I hope that we'll take part in this drafting of the model BIT with international consultants. Regarding the points raised by Nazgul Saburovna, the comments is regarding the regulatory regime of Kazakhstan on renewable energy. Nazgul Saburovna is a high professional on renewable energy sector, and I have written a number of articles on this matter. Since that Kazakhstan is still oil exporting and producing country, most of the energy is flows from the traditional energy sources, such as oil and gas, coal. That's why the regulatory regime is still developing regarding the renewable energy. We know the law on renewable support of the renewable energy. Actually, the Kazakhstan is kind of trying to have a like best practice and to implement it in the national legislation regarding, for example, feed-in tariffs in renewable energy sector. I'm sure that this regulatory framework will develop in Kazakhstan regarding the renewable energy, and this matter will be maybe positively or maybe negatively will appear in future. Regarding the second, it's mostly kind of recommendation regarding the publishing the monography. I hope that I will do it. Will be positively finalizing all of the PG dissertation and try to publish it in English language, maybe translated into Russian and Kazakh language as well. Thank you for your recommendations, comments, very carefully noted. Thank you very much for your attention.
Thank you very much, Mr. Kuzhatov. Please take your seat. And dear colleagues, we will now proceed to the next section in our session, that is the discussion. In the discussion, with your permission, I will briefly summarize the 4 unofficial reviews we have received, 2 from Kazakhstan and 2 from foreign countries. And then we shall invite members of the audience to also make their comments on the thesis. Уважаемые коллеги, сейчас мы переходим к дискуссии, и с вашего разрешения в дискуссии я вначале оглашу краткое содержание 4 неофициальных отзывов, поступивших на диссертацию, 2 из Республики Казахстан и 2 из зарубежных стран, после чего мы предоставим слово коллегам в аудитории, чтобы коллеги также могли высказать свои мнения по поводу диссертации. Позвольте мне начать с 2 отзывов, поступивших из Республики Казахстан. I will start with 2 reviews from the Republic of Kazakhstan. Reviews are available online. With your permission, I will only summarize the reviews and focus on their conclusions in the interest of time. Уважаемые коллеги, поскольку полные тексты всех отзывов находятся в распоряжении Совета и опубликованы на сайте, я сосредоточусь только на выводах, которые представили неофициальные рецензенты. Итак, первая рецензия поступила из Каспийского общественного университета, из Высшей школы права Адилет, от доктора юридических наук, от профессора Ильясовой. Профессор Ильясова очень подробно излагает свое мнение по поводу диссертации и в конце приходит к такому выводу, что все изложенные замечания являются дискуссионными, некоторые носят редакционный характер и не умаляют достоинств диссертации, ее значения в развитии инвестиционного права, установлении правового режима инвестиций, обеспечении баланса интересов инвестора и государства и в практике разрешения инвестиционных споров. В этой связи рецензент, руководствуясь вышеизложенным, считает, что диссертация Кужатова Багдата Гиззатовича на соискание ученой степени доктора PhD представляет собой самостоятельное научное исследование, соответствует требованиям, предъявляемым к диссертационным работам, а ее автор заслуживает присуждения ученой степени доктора PhD. Второй отзыв поступил от академика Сулейменова Майдана Кунтуаровича. Важно, что академик подчеркивает в самом начале, что тема диссертации, безусловно, является малоисследованной, я бы сказал, да, почти неисследованной. Если в России появилось несколько статей на данную тему, то в Казахстане их нет, кроме статьи самого академика Сулейменова. И он также подчеркивает, что, пожалуй, диссертация господина Кужатова – это первое монографическое исследование на данную тему на постсоветском пространстве, возможно, и в мировом пространстве, что очень важно. Затем академик Сулейменов на 11 страницах очень подробно рассматривает диссертацию господина Кужатова и в конце приходит к следующему выводу. Эти замечания не являются существенными, они не колеблют общего вывода о том, что диссертация господина Кужатова написана на высоком научно-теоретическом уровне, обладает безусловной новизной, имеет большую практическую ценность и будет способствовать укреплению позиций Казахстана. Ввиду большого практического значения диссертации рекомендую опубликовать ее в виде монографии, только не под таким длинным названием. Могу предложить название «Справедливый и равноправный режим в договоре к энергетической хартии». И основной вывод: автор диссертации господин Кужатов, безусловно, заслуживает присуждения ему искомой степени доктора PhD. Сейчас позвольте перейти к двум отзывам на английском языке, поступившим из зарубежных стран. Now, ladies and gentlemen, let me briefly summarize two reviews from foreign countries. The first one was written by a professor of law at the Universitat Pontificia de Comillas, Rafael Gil-Nievas. Like the other unofficial reviewers, he described at length in his review the focal points of the thesis, and he concluded at the end, I certainly believe that conducted research could be useful guidance material for academics and scholars as a theoretical basis for further research. Practicing lawyers wanting to better understand the scope of the FET, government bodies wanting to understand the relationship between regulatory measures and how they fit with FET, ECT contracting parties in the framework of modernization reforms, states to take into account of if they wish to incorporate the FET standard in future international investment agreements, investors to take into account relevant regulatory measures. In conclusion, Mr. Kuzhatov has done significant independent research, and his thesis deals with a very important and timely issue and contributes to the development of international investment law. And last but not least, there is an unofficial review supplied by a senior partner for Squire Patton Boggs, Mr. George von Meeren. This review is relatively shorter than the other ones. However, it means it is very focused on the reviewer's conclusions. And the conclusions are as follows. I have evaluated Mr. Kuzhatov's proposals in the context of issues I have faced as counsel for sovereigns. I have also evaluated the solutions that would have been driven by the proposals. The proposals are extremely well developed and present what I believe are appropriate solutions to the inherent tension between investor protection and a sovereign's right to regulate in the Energy Charter Treaty context. I am certain that Mr. Kuzhatov's proposals will be of assistance both to lawyers who act as counsel in Energy Charter Treaty cases and to the arbitrators who decide those cases. In judging legal scholarship, it is one thing to describe the history and existing state of legal rules or principles. It is quite another thing, and much more important, to be able to show effectively why and how the law should evolve. Mr. Kuzhatov has achieved both with flying colors. So it is very important, according to the fourth reviewer, that Mr. Kuzhatov has done both a positive analysis, an analysis of the current law, and also a normative analysis of the law. That is a law, how it should be in the future, the law de lege ferenda. Having said this, ladies and gentlemen, let me proceed and ask if there are any further comments in the audience, comments on the work carried out by Mr. Kuzhatov. As I might not see all the hands, may I ask Professor Idrisheva to help me in identifying potential speakers. Дамы и господа, позвольте мне теперь пригласить коллег в аудитории высказать мнение. Я вижу доктора Ешниязова. Очень приятно видеть вас.
Good day, dear ladies and gentlemen. My name is Nurjan Eshniazov. I am assistant professor of Department of International Law here in Glasgow University. And first, I taught Mr. Kuzhatov the course of academic research, academic writing. And as the member of Research Committee of Higher School of Law, as a member of Research Committee of Higher School of Law, I've been a witness of the birth, of the growth, and of the finish of this dissertation, during last 3 years, I participated all the discussions, all annual reports, all pre-defenses, and I'm glad to see the result of this work right today. I saw a lot of dissertation, candidate dissertation, PhD dissertation in my career, and I can describe the dissertation of Mr. Kuzhatov as a significantly new level, new degree for Kazakh jurisprudence. It should be noted that Baghdad has published an article in the first quartile Scopus journal and could gain the PhD level without any defense of PhD. But he preferred not to take this easy way. He bravely decided to defend this thesis because this thesis is too good to be abandoned. It should be defended, and I think it is defended today. I am sure that this thesis will be useful not only for Kazakh jurisprudence as for sphere of science, but in practice, both Kazakh and international. So I am fully sure that Baghdad Kuzhatov deserves the degree of philosophy doctor in jurisprudence, and I ask the respective council to support him today. Thank you very much.
Thank you very much, Dr. Yeshniyazov. Do we have any other speakers in the audience who would like to express their views?
Если можно, дайте мне слово, пожалуйста.
Прошу, с удовольствием.
Здравствуйте. Я Жатканбаева Айжан Эржановна, и я хотела бы просто пару слов сказать, не отнимая вашего драгоценного времени. Я хотела бы сказать непосредственно о самом Багдаде. То есть это очень целеустремленный человек, который целенаправленно шел к своей цели, нашел такую интересную тему. Я уже не буду говорить об ее актуальности, потому что, наверное, лучше, чем сказал Майдан Кунтуарович, об этом уже не сказать. Эта тема действительно интересна и с практической точки зрения, и особо актуальна в свете тех реформ, конституционных реформ, которые произошли летом 2022 года. И, скорее всего, это те вопросы, с которыми мы столкнемся в той или иной степени в процессе деятельности Конституционного суда Республики Казахстан. Но непосредственно о самом Багдаде, еще раз повторяю, он очень целеустремленный, личность цельная, личность научно сконцентрированная. Я хотела бы подчеркнуть его значимость с точки зрения комплексного подхода, и с точки зрения конституционного права, и с точки зрения инвестиционного, гражданского и других отраслей права. Получилась такая очень интересная диссертация, которая действительно была бы, которую было бы, наверное, лучше действительно в монографии сдать, и для того, чтобы мы уже использовали в своей практической деятельности при преподавании и при других моментах, и особенно мы бы могли рекомендовать его непосредственно для сотрудников соответствующих министерств, ведомств. Ну, вот на этом, наверное, я закончу, не обременяя вас своим присутствием. Спасибо.
Спасибо большое, госпожа Жатканбаева. Ваше мнение не только не обременяет, а исключительно важно для этого совета. Спасибо большое, что поделились. Ladies and gentlemen, dear members of the Dissertation Council, may I ask whether anyone else would like to share their opinions and comments regarding Mr. Kuzhatov's PhD thesis? If there are no further views, then may I suggest that we proceed to the next stage. that is to a secret voting. At this stage, it is necessary to elect a counting commission consisting of 3 members. May I ask if there are any volunteers or suggestions in the audience? That is, colleagues who would like to become members of the counting commission, who will count votes?
We have two appointed and we were the members of secret voting council members.
Оппонент может? Excuse me. Оппонент положить не может?
Мы готовы, но надо, чтобы не отменили наше решение.
Прошу прощения, вас плохо слышно. Если можно, в микрофон.
Это всегда было правильно. Официально не могут. Если изменили, но раньше всегда было.
Лучше не рисковать.
Да лучше не. Спасибо за доверие. Чтобы это было решение.
Прошу прощения, мне очень плохо слышно.
Может быть, Абай или Багдат, вы просуммируете в микрофон?
Вот сейчас идеально было слышно. Да.
Министерство науки отменит решение. Пока есть возможность поменять других коллег.
Сергей Вячеславович, просто так получилось попытка, что у нас члены совета участвуют онлайн.
Коллеги, в вашей конференц-комнате, кажется, микрофон не очень хорошо работает. Можно в микрофон, который на трибуне, нас проинформировать о вашем решении?
Из 6 членов диссертационного совета сложилась сегодня такая ситуация, что половина членов совета присутствует онлайн, в том числе и Сергей Вячеславович. И только 3 мы находимся офлайн. Поэтому исходим из имеющегося факта.
Адильбек, вы слышите?
Нет, тоже не слышно.
Я тоже не слышу.
Абай Блач, можно микрофон в трибуну сказать? Просто нам вообще не слышно. Или Багдат, может, вы как-то про... Ага.
Так, уважаемый Сергей Вячеславович, дело в том, что из 6 членов диссертационного совета половина, ровно 3 участвуют онлайн, и 3 участвуют офлайн. Поэтому нам придется исходить из факта, который имеет место быть.
Все, отлично. Таким образом, я сейчас отправлю линк коллегам, которые онлайн. Мы заполним формочки, и подсчет голосов офлайн будет происходить в аудитории. So, dear colleagues, dear Dr. Tusupov and dear Dr. Young, I will now...
Оппоненты голосовать согласно новым правилам. Речь идет о членах счетной комиссии. Предполагается, председатель также будет заседательствовать счетной комиссии, втроем члены комиссии, которые будут читать голоса. Бюллетени вы раздадите и проголосуете.
Да, это наиболее верный вариант.
Ladies and gentlemen, according to the decision and voting, we appointed the following persons as the members of voting commission. Chairman will be me, Abay Aglaylı, and members Sara Timothy and Jamiva Rosa. And now, after that, I will send you paper-based ballots, and the online members will get the link to voting. Согласно которому председатель будет в счетной комиссии я, и членами будут Джамиева Роза и Сара Гимназия. Гостей просим выйти из аудитории, мы сейчас будем голосовать в зале, потом...
Адильбек, вы получили линк?
Да, получил. Спасибо, Сергей. Я проголосовал уже.
Хорошо. Horace, you have received the link, right? Good.
I'm providing ballots, paper-based ballots for 5 members, and online members will get to the voting. You can start voting. Please underline one answer in paper-based, пожалуйста, отметьте только один вариант.
Сергей Васильевич, механизм голосования троих членов совета находящийся онлайн. Пожалуйста, объясните, может, вдруг кто-то не знает.
Мы, уважаемые коллеги, 3 члена совета, которые находятся онлайн, получили ссылку на Google форму. Форма анонимная, форма предусматривала 4 варианта ответа от отклонить диссертацию до рекомендовать диссертацию для присуждения ученой степени PhD. Я получил ссылку на форму от секретаря нашего заседания, передал ее доктору Тусупову и доктору Янгу, и 3 члена совета, имеющие право голоса, то есть доктора Тусупов, Янг и я, уже проголосовали по этой электронной форме.
Нам надо продемонстрировать, пусть нам продемонстрируют. Ну да, подойди, как бы не слышно, о чем-то, об этом.
Oh, should I send you the link to the results?
Yeah.
Shall I send it via Zoom? Абай, прошу прощения, я снова не слышу. Можете воспользоваться трибуной, пожалуйста? The results via Zoom, right? Okay, I will do it in a moment. Thank you.
Надо спросить, понятна ли членам совета вот эта процедура, и чтобы они подтвердили, что они отправили.
Dear colleagues, for the sake of formality, the chair lady of the council asked you to kindly confirm that you understand the voting procedure and that you have submitted your votes anonymously via the form provided.
Confirmed. Thank you.
Yes, I can also confirm that.
Thank you very much. And now, pursuant to the request from the chairman of the counting commission, I will share into the Zoom chat a link to the results of the voting. I'm now copying the link into the chat box. I am making the link public and visible to all. And here we are, dear colleagues.
Теперь попрошу членов комиссии подойти, вскрыть, посчитать. Итак, в урне 5. Да, в урне 5 бюллетеней.
Пять бюллетеней. Раз, два, три, 4, 5. 5 за.
Испорченных нет?
Нет, испорченных.
Все за.
Да, все за. Подписываем.
Сейчас не принесут. Здесь они...
Фамилия другая.
Да.
Исправить. Да. Так.
Можем приглашать?
Я сейчас вам Ой, девочки, не пробовали. Можно, как бывает, когда вот так вот онлайн много. Что приехало. Не говорите, это вообще ужас. На будущий урок вы поможете. Но максимально участвую онлайн.
Уважаемые коллеги в аудитории, Сара Кимадиевна, Абай, объявлять результаты кто-то будет из вас, да, вероятно, или председатель счетной комиссии, или председатель совета.
Да, объявлять я, сейчас мы подпишем, и итоги уже есть, мы должны подписать сейчас.
Итоги, вот еще раз покажу на экране.
Dear members of the council, we have the result and we are waiting for the paper in order to sign this and officially to ourselves. Please give us the results.
Что-то мама фамилию. Нет,
Я имею в виду, если сейчас в этом правило поменяли и официально рецензенты могут голосовать, то я думаю, что...
Нет, они рецензенты уже скучно могут голосовать.
Счетная комиссия они тоже могут. Это просто не регулируется.
Да?
То есть мы могли просто не знать.
Ну, лучше не рисковать. Лучше не рисковать. Если Николаевич правильно сказал.
Блестящая защита.
Да.
Международной чести. Чем
Зачем лишние замечания совету? Знаете как, здесь не гражданский вопрос, все, что не запрещено, разрешено, могут докататься. Вот действительно, тем более, что оппоненты голосующие, но почему-то вот настаивают, что члены совета, вот, да, при постоянных требованиях, значит, говорите, вот члены совета голосуют неправильно, и к ним добавляются голоса, правильно учитывать мнение оппонентов. Ну да, получается 6 плюс 2, итого 8. А 4 на 4. Тоже. Тогда просто представьте еще, да. Другого правила не продумано. Да. Ладно, сейчас. Быстрее, пожалуйста, Света. Быстрее, давайте. А вы давайте возьмите, пожалуйста.
Можно пригласить его?
Нет.
Да, можно.
Нет, мы же не огласили еще.
А сейчас они зайдут, я перейду. Да, приглашайте людей.
Да, все можно считать, считаем, уже все только в этом. На задержку, скорее всего.
Can I start? Do you hear me? Ladies and gentlemen, we have a result. According to our rules, we have 5 offline members who got paper-based ballots, and we have 3 online members who voted online, and we have a vote, and the results are the following. All 8 members have voted, and there were no damaged paper-based ballots. All 8 members, there were no vote for return the dissertation as requiring revision. There were no vote for return the dissertation as requiring redefense. There were no reject. There were no vote for reject, request the committee for the award of a PhD. And all 8 members have voted to request the committee for the award of a PhD degree. And my congratulations. The committee voted for Mr. Kужатов to award PhD degree.
Thank you very much, Dr. Ablayli. Thank you very much. Dear colleagues, thank you everyone who was involved in this important undertaking in the whole process. Thank you very much, dear advisors, dear reviewers, and most importantly, thank you very much, Mr. Kужатов. In conclusion, let me also congratulate Mr. Kужатov on this important milestone in his life. This session is nearly over. Mr. Kужатov, do you want to say a few words at the very end of your PhD journey?
Yes, thank you very much. Thank you very much to the Education Council Chair, Council members. Thank you for supporting for me on this awarding the PhD dissertation. I very much appreciate all of your votes, your recommendations. In this line, I would like to thank you for all of you participating here. I just want to say a few words to my supervisors, Dr. Zangar Malaybay, helped me from the beginning of the dissertation. Many thanks, Madam Varmasutovich, for your help, for your time, for everything you did for me. Also, much appreciation I would like to say for Dr. Boris Sabahi. He's actually a great man who helped me on this journey. It is true that it's pro bono work of Dr. Boris Sabahi. We did actually Dr. Boris Sabahi, you know, I can now look at my laptop and see like 60 drafts of this dissertation. We had weeks, nights, days working with Borzo. He commented each my sentence and challenged my ideas. As a Professor Borzo actually already now two books on international investment protection, the fair treatment matter. He knows much everything about the problems of the FET and the proposals. We did actually great work. Thank you, Dr. Borzo, for supporting me. You joined from Washington, D.C. so early morning. Thank you for your time, for your patience, and for your full support. Thank you very much. Please visit us, Kazakhstan, and we look forward to seeing you. Also, I'd like to say many thanks to the dissertation council members who joined today from abroad, from England, Dr. Horace, Dr. Adilbek. Many thanks for your time and taking this participation on this important event in my life. Also, I'd like to thank you to Mr. Sayapin, who joined from Almaty. Thank you for your time, for your support. And here's I'd like to thank you for dissertation council members, the chair, Sarah Medina. Many thanks for your support. And Rosa Gusinina, many thanks, Abay Ablayevich. Many thanks. Here is also reviewers which participating in dissertation. Is the well-known academic Morenov. Despite that, I'm young and trying to defend my PhD dissertation. You appointed us as an opponent. Thank you for your comments, recommendations, and support on this important event. Also, I'd like to thank you for Nazgul Sabarovna, for a highly professional academic, which like writing on the energy sector of Kazakhstan, developing this sector under the law regulatory framework on this matter. Many thanks for your time as well. Please also, I'd like to thank you, Abay Ablayevich and Eugene Sergeyevich, the KazGU members who supported along the way. Also, I'd like to thank you for KazGU staff, which helped me. There is now, I don't know, the provost of the KazGU, but she is participating, Olga Sergeyevna, and Aseli, for all of the KazGU staff which helping this journey. I very much appreciate your time and good luck. Thank you very much.
Thank you so much. And once again, congratulations. And soon we'll have the pleasure of calling you Dr. Kuzhatov. And now it is my pleasure to give the floor to Professor Idrishova for her to formally close the session.
I'm congratulations. I wish you success, Mr. Кужатов. Ну, я думаю, карьеру большую давали по-русски. Thank you. Объявите, пожалуйста.
Ladies and gentlemen, our meeting is closed. Thank you very much for all of you for coming and discussing and asking questions. Thank you very much for all the online members. See you next time.
Thank you.
Thank you very much, everyone. It's
Congratulations.
an honor to meet you all. And I hope our paths cross.
Recording
again.
stopped.
Thank you so much, dear colleagues.
Surely.
It was good to see all of you.
Have a good day. Bye.
Thank you. Bye-bye.